When a person dies, somebody needs to figure out what assets that person has, the debts that they need to pay, and who receives the remaining assets after those debts get paid. This person is called a fiduciary, and there are three types: administrators, executors, and trustees. Administrators and executors are very similar. They are similar because they are both appointed during the probate process. Probate process is a court procedure that applies to assets that are only in the deceased person's name when they die. It does not include assets that are held in joint tenancy or assets that contain beneficiaries. Once a probate estate is opened, the court will appoint either an administrator or an executor. If the deceased person does not have a will, the fiduciary the court appoints is called the administrator. The administrator must follow the default laws that control what happens to the assets of a person who dies without a will. If the person who dies does have a will, the fiduciary the court appoints is called an executor, and the executor must administer the deceased person's estate by following that person's directions that they've listed in their will. Both the administrator and the executor must report to the court, and the court must approve what they do. If a person who dies has a trust and their assets are titled in the name of the trust, the fiduciary who manages the trust assets is called the trustee. In most cases, there is no court involved. However, the trustee is still responsible to administer the trust for the benefit of the trust's beneficiaries, and the law holds the trustee to some pretty high standards.